Thank you, Mr. Chairman. The current Supreme Court is one of the most corporate-friendly courts in history. Rulings like Citizens United and others have expanded the rights of corporations significantly in a variety of areas that undermine our democracy. Mr. Chairman, I'd like to enter into the record a 2013 New York Times article that reports on this troubling trend entitled, quote, "Corporations Find a Friend in the Supreme Court," end quote. I'd also like to
Without objection.
I'd also like to enter into the record an April 2nd, 2014 editorial from the Charlotte Observer entitled, quote, "Another Window to Corruption, Our View," end quote, talking about the Supreme Court's continuing to, on its path to dismantle the country's campaign finance laws.
Without objection.
Senator McKissick, you describe for us the post-Citizens United situation in South Carolina. And we've heard testimony today that the next step, because the court is on the path of saying that constitutional rights are at stake in these decisions, the path of eliminating individual contribution limits. Now, would you describe for us what you think would happen in that instance? Because I think there is agreement. That is the next Supreme Court campaign spending decision coming down the line.
Well, Senator, that certainly appears the way the Supreme Court is drifting. I think it would be certainly the wrong direction for this country to move. At this point in time, I mean, it's bad enough that you have unlimited corporate contributions coming in today that did not exist before. The worst possible thing could happen is if you also eliminated these limitations on individual giving. What you would essentially do is distort the whole playing field. And when I say that right now, whether those contributions are $4,000 or $5,000, let's say in a state race in North Carolina, if you eliminate that cap, those individuals that want to give $25,000, $50,000, $100,000 just to make certain that their policy, their view, their perspective is actually that particular perspective that wins the day before our General Assembly, that the laws are adopted that protect those potential contributors' interests. When you really think about it, it undermines the integrity of our whole system.
Well, these decisions, the Citizens United and the McCutcheon decisions, basically did not touch the individual, the contributions to individuals. Now, there's this kind of a little barrier, but when one can contribute in an unfettered way to individual candidates, that's you, that's all of us. Professor Raskin, do you think that that is the kind of undue influence that led states and the federal government to pass campaign spending laws in the first place?
I think you're absolutely right, Senator. You know, first of all, on your first point about corporations, I did a report for People for the American Way, the session after Citizens United, to situate it in precisely the context you identify, which is an aggressive pro-corporate jurisprudence on the court. And in that term of the Supreme Court, corporations won against shareholders, they won against workers, they won against government regulators, they won essentially every case that they had going on in the Supreme Court. But the idea of undue influence, improper influence, has now been taken away from Congress in the states as a legitimate rationale for regulating contributions. And the McCutcheon decision presses up very hard against the individual contribution limit, because the idea is you can't limit what people give overall. They should be able to give to everybody. That's limiting the overall quantity of speech.
Yes.
So does the regular contribution limit. The regular base limit also reduces what the candidate can spend, because if I could give you $1 million instead of $5,000, you could spend to the heavens.
I think that I share the concerns that you express about unfettered giving to individuals. And I think that does raise the undue influence concern that the people of America already have with regard to what goes on in the political arena. So with these decisions and the next decision, I have no doubt, I have very little doubt that Senator Coons is correct and Mr. Abrams acknowledged that the lifting of those individual contribution limits will be next. I think that's a huge concern, which is why I believe we need to move ahead with this constitutional amendment bill. Now, I think there's also agreement that we can put in the reasonableness standard into this bill so that the states and the federal government do not go hog wild. In addition, the Supreme Court, I'm running out of time, but they set up a standard that is probably impossible, which is that the only way that we can enact legislation in this area, aside from disclosure, would be that we have to prevent a quid pro quo, basically bribery, which is already illegal. So basically, the Supreme Court is saying, would you agree, Mr. Professor, that they're saying, well, aside from disclosure, you all can't do anything about what the Supreme Court is saying.
I think that's absolutely right. And by the way, the same people who brought us this line of decisions are now attacking disclosure, not just legislatively, and we know that there's a partisan divide on that, but also constitutionally, they're saying this is unconstitutional compelled speech under the First Amendment. It's like making the Jehovah's Witness kids salute the flag, and they are insisting there's a right to anonymous speech. So look at the political realm that they want to give to the American people. Corporations are treated like people. They can give on an unlimited basis directly to candidates. They can spend on an unlimited basis, and they don't have to tell anybody. And then they whine if anybody even calls a corporation out for doing it, saying that somehow their First Amendment rights are being violated.
Yes.
That's a pretty special First Amendment they've got.
Thank you.